And the government of Kenya is set to appeal the High Court's decision to halt the closure of the Dadaab camp.
The High Court had termed the move unconstitutional and blasted the Ministry of Interior for abuse of office in scrapping the Department of Refugees and the forced repatriation of the refugees.
NTV's Brenda Wanga reports.
A handful of members of the refugee community outside the courtroom when the news of their victory was delivered to them by their interpreter. Their joy and relief unmatched.
It's a win for the Constitution.
They, alongside between 250 and 350,000 other refugees who call the Dadaab refugee camp home, were facing an uncertain time this year. In the month of May, they would have been packing up their tents and their bags and beginning the journey back home, albeit grudgingly. The refugees had been given a 6 months reprieve after the government caved under pressure from the international community to extend the grace period before carrying out the mass repatriation and closure.
The government has accepted the request to extend the deadline for the completion of repatriation of Somali refugees and eventual closure of the Dadaab refugee complex by 6 months. However, the ongoing voluntary repatriation will continue uninterrupted.
But that is now water under the bridge. Justice Mativo ruling in a case filed by the KNCHR and Kituo cha Sheria challenging that order, declared that Kenyan and international laws had been breached by the government.
Directive issued by the third respondent, namely Major General retired Joseph Kaisari, on the intended repatriation of refugees and asylum seekers of Somali origin on 10th May 2016 is arbitrary, discriminatory, and indignified, and hence a violation of Article 27 and 28 of the Constitution, and consequently the same is null and void.
The government had argued that the closure of the camp had been necessitated by the fact that the camp was increasingly becoming a breeding ground for Islamist militants who were posing a threat to national security.
Kenya's position on this issue is not born primarily out of financial strain, but it's rather based on environmental matters as well as security risks that increasingly permanent refugee settlements pose to host communities.
However, the judge stated that the situation in Somalia is what should determine whether the refugees feel safe enough to return without fear of persecution.
The decision by the government of Kenya to collectively repatriate all refugees in Dadaab refugee camp to the frontiers of their country of origin against their will violates the principle of non-refoulement.
But while the refugees breathe a sigh of relief, they may not be out of the woods just yet. In a quick rejoinder to that groundbreaking ruling, the government is now moving back to the courts to challenge it.
We ask the government to respect the rule of law. We would like to state that the government will be appealing this judgment as soon as possible.
In the meantime, the World Bank has announced a $100 million fund that will help fund projects in the communities that have taken in refugees. This is in a move to disabuse the notion that refugees access better services than the host communities. The judiciary's overruling of the executive order on the closure of the Dadaab camp now means that that exercise that was supposed to resume in May this year may not be taking place after all. Brenda Wanga, NTV, Nairobi.